Thank you for joining us for today's paid family leave webinar for employers and HR professionals. I'm Adam Rossi with the board's Stakeholder Engagement Unit, and joining me today is Courtney Valley from our Office of General Counsel. Courtney will be on hand today to answer any questions you have. And today we will be providing you with an overview of New York State's landmark paid family leave benefit, including contribution benefit rates and updates for 2024. Information about COVID-19, and some resources to help you share with your employers. We will be using the chat feature to receive your questions today. You may enter your questions at any point during the presentation in the chat box, which is located on the right-hand side of your screen. If you see on the bottom right-hand side, there's a little chat bubble. Just click on that. The box will pop right up if it's not already. You can enter your questions at any point today. However, we are going to be holding off until the end of the presentation to answer any questions. So don't think we're ignoring you. We are just waiting at the end, and then Courtney will take a look at all the questions and answer as many as she can. If you have a question that we either don't get to today, or if you think of something after the session ends, we will be providing you with resources at the end of the presentation. Also, your name and email were given to us when you sign, or when you register, I should say. However, if you have a specific topic you'd like to discuss more deeply with the board, please feel free to share that topic along with contact information in the chat box so that the appropriate board staff can follow up with you. The chat settings are set so that only Courtney and I can see the questions that have come in, so you don't have to worry about others seeing your personal information. And also, very quickly before we get started, I just want to do a quick plug. If you are a public employer, or if you're an HR rep for a public employer and you're interested in learning about possibly opting into paid family leave, we will be hosting a webinar specifically for public employers next Tuesday. That's March 5th. If you go to paidfamilyleave.ny.gov, there's a webinar page and you can sign up there. And we will be sharing that link again throughout the presentation today. But for now, let's get started on today's presentation. As I mentioned, we will be reviewing some important information regarding New York State's paid family leave. And as employers and HR professionals, you do play a critical role in the paid family leave process and in helping employees navigate this important benefit. So today, we'll start with providing you with a brief refresher on New York paid family leave and how it works. We will update you on the 2024 benefit and contribution information. We'll review who is eligible for paid family leave. We'll review some key responsibilities as an employer or an HR professional. We'll go over some similarities between paid family leave and FMLA. We'll discuss New York State's COVID-19 quarantine leave. And then finally, as I mentioned, we will highlight some resources that are available to you and then take your questions. To start, though, we're going to give you a little bit of background. In April of 2016, the New York paid family leave, which is the nation's strongest and most comprehensive paid family leave policy, was signed into law. Paid family leave is employee-funded insurance that helps employees be there for their family when they're most needed. Because of paid family leave, workers across New York no longer have to choose between caring for their loved ones and their jobs, as we now have employee-paid insurance to help in these critical times. New York State paid family leave provides you with a structure to help your employees care for their families in times of need. Paid leave has been shown to increase workplace morale and employee retention. Fully funded by employee payroll contributions, New York State paid family leave provides job-protected paid time off to employees who need time away from work to bond with a newly born, adopted, or foster child, care for a family member with a serious health condition, or assist a loved one when a family member is deployed abroad on active military service. Under legislation signed into law in March of 2020, paid family leave also provides paid time off and job protection so employees can care for themselves or for their minor dependent child when under a mandatory order of quarantine or isolation due to COVID-19. We will go into more detail on these uses later in the presentation, as they are a bit different from the others. In addition to paid time off, New York paid family leave also has strong employee protections. Employees are guaranteed to return to the same or a comparable job after taking paid family leave. A comparable job is defined as a position with comparable employment benefits, pay, and other terms and conditions of employment. Employees are guaranteed continuation of health insurance on the same terms as if they had continued to work while out on paid family leave. If employees contribute to the cost of their health insurance, they must continue paying their portion of the premium while on leave. Employees are also guaranteed protection from discrimination and retaliation. Requesting or taking paid family leave cannot be held against them. As an employer or HR professional, it may be helpful for you to know the kinds of questions employees are asking, which could help direct the guidance you provide and the materials you make available. These are the top questions to the PFL helpline from employees. We'll cover the answers to all of these throughout today's presentation. First, though, let's walk through a quick review of the 3 basic uses of paid family leave. We'll start with bonding with a child. Paid family leave provides both parents time to bond with a new child within the first 12 months of the birth, adoption, or foster placement of the child. Parents who work for different employers can take paid family leave at the same time to bond with the same child. Parents who work for the same employer can take it at the same time unless their employer prohibits it. In that case, they could take the leave separately over the first 12 months following the child's birth, adoption, or foster placement. It is important to note that expectant parents cannot take paid family leave for their own pregnancy. You can take it after the baby is born because paid family leave is used to care for somebody else, not for your own health condition. So the pregnancy itself would not be eligible for paid family leave since that's your own condition. But after the baby is born, then you could take it. A parent may be able to take paid family leave before the actual adoption or placement of a child, however, if an absence from work is required for the adoption or the placement to be finalized. The next type of leave is for employees who want to care for a spouse, domestic partner, child or stepchild, sibling, parent or step-parent, parent-in-law, grandparent, or grandchild who has a serious health condition. We have a few important notes here for family care. In terms of domestic partner is defined broadly under the paid family leave law. It includes people who are not related by blood in a manner that would bar marriage in New York State and are dependent on one another for support. So, for example, an employee may be able to prove that they're in a domestic partnership by showing that they own property together or if they have children in common. A legal relationship is not necessary. It does not matter if family members live outside of New York State or even outside of the country. Employees can take paid family leave to care for a family member as long as they're within close and continuing proximity. So in other words, present at the same location as the family member they're caring for during the majority of the paid family leave period. This may include necessary physical care, emotional support, visitation, assistance in treatment, transportation, arranging for a change in care, assistance with essential daily living matters, as well as personal attendant services. In order to take this type of leave, the employee's family member must have a serious health condition. A serious health condition is defined as an illness, injury, or condition that requires either inpatient care in a hospital, hospice, or residential facility, or continuing treatment or supervision by a healthcare provider. The third type of leave is for assisting during a military deployment. Paid family leave benefits are available when a family member is deployed abroad on active military service, or who has been notified of an impending call or order of active service abroad and assistance is needed. Reasons for paid family leave for an active service deployment are the same as the military provisions of the Federal Family Medical Leave Act, which is also known as FMLA, and they cover the employee's spouse, domestic partner, child, or parent. There are a number of instances where paid family leave will help, and you can see them right here on your screen. And as we mentioned, before we move on, we do have 2 uses of paid family leave related to COVID-19. And again, we will cover those in a few minutes. For now, though, let's take a look at the program benefits and contributions for 2024. Eligible employees are able to take up to 12 weeks of paid family leave at 67% of their average weekly wage, capped at 67% of the New York State average weekly wage. An employee's average weekly wage is based on their last 8 weeks of pay prior to taking paid family leave. For 2024, the New York State average weekly wage is $1,718.15. That means the maximum weekly benefit for 2024 is $1,151.16. And this is $20.08 more than the maximum weekly benefit from 2023. It is important to note that employees can take this paid time off all at once or intermittently. However, it must always be in full day increments. As I mentioned, paid family leave is fully funded through employee contributions. The contribution rate is reviewed annually, and it is subject to change by the New York State Department of Financial Services. For 2024, the payroll contribution is 0.373% of an employee's gross wages each pay period. The maximum annual contribution is $333.25, and this is $66.18 less than in 2023. Employees earning less than the current New York State average weekly wage of $1,718.15 will contribute less than the annual cap of $333.25, consistent with their actual wages. To estimate deductions, we have an employee weekly deduction calculator, and that is right on our paid family leave website. You can see the link there on your screen. But again, if you just go to paidfamilyny.gov, there's also a section where you can find the calculator there as well. So to summarize the benefits and contributions for 2024, the maximum weekly benefit has increased from $1,131.08 to $1,151.16. And also, as of January 1st of 2024, employers can deduct at the rate of 0.373% of an employee's gross wages each pay period, but capped at an annual maximum of $333.25. So now that we've covered the types of leave, the benefits, and the costs, let's now review who is eligible for paid family leave. Most private employers with 1 or more employees are required to have paid family leave insurance for their employees. Public employers may opt into the program. Employees of public employers who are represented by a union may be covered if paid family leave is collectively bargained. For covered employees, eligibility for taking paid family leave depends on meeting specific requirements for the amount of time the employee has worked for their employer. Full-time employees, including domestic workers, who regularly work 20 or more hours per week, are eligible for paid family leave after 26 consecutive weeks of employment with the same employer. Part-time employees who work a regular schedule of less than 20 hours per week are eligible after working 175 days, which do not need to be consecutive. And we want to note that citizenship or immigration status is not a factor in determining employee eligibility. Paid family leave coverage is not optional for eligible employees. Employees can waive coverage, though, if they regularly work fewer than 20 hours per week and won't work 175 days in a year, or if they regularly work 20 or more hours per week but won't be in employment with that employer for 26 consecutive weeks. We always like to say that seasonal workers are a pretty good example of this, since they may work full-time, but they're only working for a few months out of the year. If an employee does meet the criteria for waiving coverage, the employer must provide them with a waiver form, which is available at paidfamilyleave.ny.gov, and you'll see the full link right there on your screen. Employees who properly file a waiver will not make contributions and will not be eligible for paid family leave benefits. And employers, you should keep a copy of an employee's waiver on file. Now, if an employee's schedule changes such that they no longer qualify for a waiver, then that waiver will automatically be revoked within 8 weeks of the schedule change. An employee can also voluntarily revoke a waiver at any time. If an employee's waiver is revoked, their employer will begin taking paid family leave contributions and collect any retroactive amounts due. Please keep in mind, however, that any amounts collected in excess of the paid family leave premium charged by your carrier must be promptly returned to the employee. Now let's review how employees request paid family leave and your role as the employer in the process. So here's how the paid family leave process works. Before applying, the employee must notify the employer at least 30 days before their leave will start, if it's foreseeable. Otherwise, they must notify their employer as soon as possible. Next, the employee will obtain the request form package for the type of leave that they need to take and complete the request for paid family leave form, which is Form PFL-1, and follow the instructions on the cover sheet. The employee will make a copy for their records and then submit it to the employer. You as the employer must fill out their section of the form, you as the employer must fill out your section of the form and return it to the employee within 3 business days. So this information includes items such as your address, an FEIN number, the employee's date of hire, and the last 8 weeks of wages. If the employer does not complete the portion of the form for the employer section of the form, then the employee can still submit the form, and they cannot be denied solely based on the employer not filling out their portion. Employees will submit Form PFL-1, the other requested forms specific to the leave they are taking, and any supporting documentation directly to the employer's paid family leave insurance carrier. They can submit the request before or within 30 days after the start of their leave before they risk losing benefits. In most cases, the insurance carrier must pay or deny benefits within 18 days of receiving the completed request package or the employee's first day of leave, whichever is later. Employees can get paid family leave request forms from their employer, from the employer's insurance carrier, or directly from paidfamilyleave.ny.gov/forms. If for some reason an employee's paid family leave request is denied, or if they have another claim-related dispute, such as the amount of benefits or the timeliness of an insurer's decision, they may request to have the decision reviewed by a neutral arbitrator. The insurer, or the employer if they're self-insured, will notify the employee of the reason for the denial and provide them with information about requesting arbitration. Arbitration for paid family leave is handled by NAM, which is National Arbitration and Mediation, and more information on arbitration is available on NAM's website. So as mentioned earlier, an employer may not discriminate against an employee for requesting or taking paid family leave, and that employee is guaranteed job protection with the same or comparable job upon return from paid family leave. If an employer does not return an employee to the same or comparable job, terminates the employee, reduces the employee's benefits, and or pay or disciplines the employee in any way as a result of the employee requesting or taking paid family leave, that employee can file a discrimination claim with the Workers' Compensation Board. An administrative law judge may order an employer to reinstate the employee, pay any lost wages, pay attorney's fees, and pay up to $500 in penalties. The process and forms are available at paidfamilyleave.ny.gov, or employees can call the Paid Family Leave Helpline for assistance at 844-337-6303. Paid family leave was designed to be easy for workers and employers, so I'm going to now walk you through a quick checklist of employer responsibilities. Again, most private employers in New York State must have paid family leave insurance. To make sure that you do, first step is always to ensure that the coverage is in place. So generally, if employers are required to carry disability insurance, they're also required to carry paid family leave. This insurance is generally added to an existing disability insurance policy. Employers who are self-insured for disability must purchase a separate paid family leave policy or apply to the New York State Workers' Compensation Board to self-insure. For a list of insurers offering paid family leave policies, you can visit the paid family leave section of the Department of Financial Services website. That is DFS for Department of Financial Services .ny.gov/PFL. Next step is you're going to want to inform your employees. Employee handbooks and or other written guidance to employees must be updated to include information on paid family leave. To make this easy for employers, we have posted model language on the employer section of paidfamilyleave.ny.gov. You as the employer can customize it, or you can just fill in the few blanks and print it as is. The next step is to collect payroll contributions. As we noted, employers should be withholding at the 2024 contribution rate as of January 1st of 2024. You'll want to offer waivers to employees who qualify for one. And just to review, those are employees who regularly work fewer than 20 hours per week and won't work 175 days in a year, or who regularly work 20 or more hours per week but won't be in employment for 26 consecutive weeks. If an employee meets the criteria for waiving coverage, the employer must provide them with a waiver form. As we shared earlier, if an employee waives coverage, they will not make contributions and they will not be eligible for paid family leave benefits, and employers should keep a copy of this waiver on file. You also want to post an employee notice. Insurance carriers provide employers with a notice of compliance, which is known as Form PFL 120, also known as a notice to employees, stating that they have paid family leave insurance and providing employees key information about the benefit. Self-insured employers, you can get this notice by contacting the Workers' Compensation Board at certificates@wcb.ny.gov. Employers must post and maintain this notice in plain view, similar to how the signage for your workers' compensation and disability insurance is displayed. And employers who receive paid family leave claim must complete the employer section, which is Part B, on Form PFL-1 and return it within 3 business days. The employer will be asked to provide the employee's last 8 weeks of gross wages and calculate the average weekly wage. And employers should be sure to discuss any specific leave tracking or any other processes with their paid family leave insurer. So, next up, we are frequently asked about the similarities and differences between paid family leave and FMLA, so let's go over those real quick. There are several similarities between New York's paid family leave and the Federal Family and Medical Leave Act. Both do provide leave for bonding with a child, caring for a family member with a serious health condition, and assisting a loved one who is deployed abroad on active military service. Employees are also guaranteed that they'll return to the same or a comparable position and that their health insurance should continue on the same terms as if the employee continued to work. If employees contribute to the cost of their health insurance, then they must continue to pay that portion of the premium cost while on leave. However, there are a number of key differences. First off, paid family leave is paid, whereas FMLA is not paid. All private employers will carry PFL insurance. FMLA does not include insurance, and it has a 50-employee threshold for eligibility. The length of time an employee must work is different. PFL, an employee who regularly works 20 or more hours per week, must be in employment for 26 consecutive weeks for that employer. And an employee who regularly works fewer than 20 hours per week must work 175 days for the same employer, which do not need to be consecutive. For FMLA, employees must have worked for a full year and 1,250 hours in the last 52 weeks to qualify. One of the biggest distinctions is that under New York's paid family leave, an employee takes leave to care for someone else, not for their own health condition. With FMLA, employees are allowed to take leave for their own health condition. PFL is only taken in full day increments, whereas FMLA may be taken hourly. And lastly, under PFL, employees do not need to use other paid time off first. So as I mentioned earlier, there are two additional uses of paid family leave that took effect in 2020 under emergency legislation enacted in response to the COVID-19 pandemic. Though the pandemic state of emergency has ended, and not many people are quarantining anymore with COVID-19, this legislation cited no end date, so these laws are still in effect, so we just want to make sure that you are aware of them as an employer. Depending on the size and type of the employer, the legislation provides benefits for either paid sick leave or a combination of New York paid family leave and disability benefits if an employee is under an order of mandatory or precautionary quarantine or isolation due to COVID-19. This is the only time employees may receive paid family leave and disability benefits at the same time. It also gives employees access to paid family leave if their minor dependent child is under an order of mandatory or precautionary quarantine or isolation due to COVID-19, up to a maximum weekly benefit of $840.70. More detailed information about taking paid family leave for a personal quarantine or a child's can be found at paidfamilyleave.ny.gov/COVID-19. Note, there is no hyphen between the COVID-19, it's just straight COVID-19, one word. And the page also includes information about New York State's COVID-19 paid sick leave requirements, FAQs, application forms, and more. So as we continue working closely with employers to ensure successful implementation of paid family leave throughout New York State, there are a number of resources to help. Complete details on paid family leave are available at paidfamilyleave.ny.gov, along with other resources, including paid family leave request forms and fact sheets, weekly deduction and benefit calculators, and information about COVID-19 quarantine leave benefits. There is also a special updates for 2024 webpage, which is available at paidfamilyleave.ny.gov/2024. And there you'll find a number of employer resources to help explain and communicate the benefit and deduction changes. These include an overview of the changes, FAQs, some updated model language for employee materials, an employee notice of paid family leave payroll deduction template, and a statement of rights for paid family leave. Employers and employees can also contact the paid family leave helpline at 844-337-6303 for assistance Monday through Friday from 8:30 a.m. to 4:30 p.m. If you are not already subscribed for email updates on paid family leave, You can subscribe by clicking the Get Updates button on the paidfamilyleave.ny.gov homepage. And finally, we also want to make you aware of the board's Office of the Advocate for Business. The Office of the Advocate for Business is the liaison between New York's business community and the Workers' Compensation Board, giving employers one place to contact for answers to their workers' compensation questions, as well as any questions employers may have about paid family leave as it relates to your business. You can contact the Office of the Advocate for Business at advocatebusiness@wcb.ny.gov. And another plug here, we will be hosting a webinar for business owners on next Wednesday, that is March 6th. And again, we will cover everything you need to know as a business for workers' compensation, disability benefits, and paid family leave. I will be doing that presentation as well, so I hope to see you on there joining me again. But for now, that is all for this presentation. We hope you found this information helpful. We are now going to take the rest of the time to answer any questions that you have. We do have a number of questions that have already come in, so I'm going to let Courtney review those. But again, if you have questions now, feel free. We have till 1 o'clock, so just enter any question you have right into the chat box. I did see a couple people asking if we will be providing a copy of this presentation. The answer to that is yes. We will be providing you with a copy of the slide deck as well as a recorded version of this presentation. Make sure you're signed up for email notifications so you know when that is available. I'm going to put this section right up here, this slide. So again, just if you're not already signed up for emails, you can do that right at our website. Just click the Get Updates button. We do have a previous version from 2023 on our website now. So the information obviously is not up to date with the new 2024 rates. But if you need something to reference quickly while this is getting updated, we do have a previous version from 2023 on our website now. But with that, again, we do have a number of questions that have already come in, and I want to get to those. So I am now going to hand it over to Courtney, and she's going to answer what she can.
Great, thanks, Adam. The first question I see here is, we have been deducting from the paychecks of our seasonal employees who work in the summer and on school breaks. Am I correct? We only need to give a refund to seasonal employees if our insurance gives us a credit on our bill. So no, that's not correct. If you have employees who qualify for a waiver, so if we're talking about seasonal employees, if this is an employee who regularly works 20 or more hours per week, but they're not going to be in employment for 26 consecutive weeks, you are required to offer them a waiver before you take any deductions. You cannot take deductions from someone who qualifies for a waiver. If you offer them the waiver and they decline, then you can take deductions from them, but it is not optional for the employer to offer the employee a waiver. If they qualify for a waiver, you are required to offer it to them. And if you took deductions in error, you have to refund them. Okay, next question here is, do we need to refund seasonal employees who are no longer our employees? For example, they were terminated in 2022. If you did not offer them a waiver and they qualified for one and you took deductions from them in error, you do need to refund them any deductions taken in error. Yes. Okay, next question here is, there are two companies. One company only hires seasonal employees and we have waivers on file for them. The employee was later added to the other company and they work less than 20 hours per week and payroll deductions are taken from them. Do we count the days worked as a seasonal employee in our eligibility calculation, even though we have a waiver on file for that company since we are the joint employer? I cannot provide legal advice, so I'm not going to be able to give you eligibility determinations or guidance on your business practices. Eligibility benefit amounts and deduction amounts are calculated separately per covered employer. So that's kind of one prong of this. If we're talking about the same employer, again, eligibility is calculated separately per covered employer. So that would include all of the employee service for that covered employer. And again, if the employee qualifies for a waiver, the employer is required to offer it to them prior to taking any deductions. And if the employee executes it, they cannot take any deductions from that employee unless their schedule changes so that they no longer qualify for the waiver. And again, if you took deductions from them in error, you need to refund those deductions. Okay, next question here says, can you please provide me with a breakdown on how the employee's time is calculated? I am not sure what this question is referencing, so if you're the person who asked it, if you want to provide additional detail in the chat, hopefully we'll get to it, as I'm going through. Otherwise, you can always feel free to include the information with your email address, and if we don't get to it, I can address it separately in an email, but I'm just not sure what you're asking, so I'm going to keep going in the list, but please feel free to put in the chat additional context. Okay, next question here is, if a person on disability is requesting PFL, is this concurrent, so DB and PFL combined, or consecutive, so DB first and then 12 weeks of PFL? So you can't take statutory disability and PFL at the same time, except in the very, very narrow circumstance of COVID-19 leave, but that's almost non-existent. It's an extremely narrow situation where they can be taken at the same time. Generally, when we're talking about disability and paid family leave, they must be taken separate. They cannot be taken at the same time, so it would be consecutive. There is a combined maximum in the statute of 26 weeks of disability and PFL. So in a 52-week period. So if an employee uses disability and then they use PFL, they may be eligible for all 12 weeks of PFL. It's just that in a 52-week period, the employee is only going to be eligible for a maximum of 26 weeks of disability and PFL combined, so it is a combined maximum. Okay, next question here is, do faculty who are not covered under PFL need to vote to request coverage? So if these are employees that are not covered employees under the law, so they're not considered employees in employment of a covered employer, the only way that they're going to have coverage is if they're unrepresented, the employer can opt in on their behalf. But if they're going to take contributions from those employees who are not covered, who the employer is now voluntarily covering, more than half of the employees have to vote like, yes, that's okay. They have to assent. So more than one half of the employees have to assent to the contributions. But generally speaking, if we're talking about an employer opting in to voluntarily cover employees who otherwise aren't covered, they can do that. They just, if they're going to take contributions, they have to take a vote, and the employees, more than a half of the employees, have to agree for the contributions. Okay, I see a question here about the process for if you get a penalty for not having PFL coverage, how that works. I am going to give you the compliance number. I'm not an expert on the compliance side of things and exactly how that works. So I will put in the chat the compliance number. So let me do that. Okay, so the compliance number is now in the chat. And that's what I would call for any questions about penalties and how that works. Okay, next question here is, if the employee submits the forms to the employer before their leave beginning, because they're going to take bonding for childbirth, how should the employer go about completing the dates of leave and pay information? Assuming the baby is born at any given time, the pay will not be for the 8 weeks prior to leave in some cases. Yes, so that's a good point. Some carriers will accept pre-filed claims, and in many cases, if the employee works full-time, they're kind of making the same amount all the time, and so the 8 weeks may not change. Another possibility is that the employer fills out all the information, but the carrier will ask for updated wage information at the time that the employee actually does end up going out on leave. Employees have 30 days from the first day of leave to apply for benefits before they risk losing benefits. So there's kind of a lot of different ways that this can go about. You can also contact your disability and PFL insurance carrier because many of them do accept pre-filed claims, especially for bonding, but they are not required to. And they may have a process in place too, like if they don't accept pre-filed claims, for how they'll reach out to you for updated wage information and things like that, because this is a common situation, and your carrier may have a specific process in place for handling that. Okay, next question here is, what are the requirements for employers to be self-insured for FMLA? I think you mean PFL. FMLA is federal, and we don't have jurisdiction over it. It's also unpaid. So I'm going to answer it as if you're talking about paid family leave, but if that's not the case, please feel free to respond in the chat with additional context. But to be self-insured for paid family leave, you have to be able to demonstrate that you have the ability to pay claims. So, and it's also for disability and paid family leave. So you're not going to be able to self-insure just for paid family leave, but you have to demonstrate that you have the ability to pay claims. There's a security deposit that you need to do, and there's an application. And I will put in the chat here is a link to the self-insurance portion of the website, which has a little bit more information. And you can contact the self-insurance office if you have more specific questions about the application process and things like that. Okay, next question here is, does the employee have to fill out both FMLA and PFL forms? And the answer is likely yes, but we do not have jurisdiction over FMLA because it is a federal law. So I think in many cases, like the FMLA and the PFL, while they're similar, the eligibility requirements are different, and I think the applications are in a lot of cases different as well. So likely they will need to fill out both, but we do not have jurisdiction over federal law, so I can't give you a definitive answer. Okay, next question here is, can a salaried employee use PFL in a reduced work week schedule, so working 3 days and 2 days of New York PFL? So the answer is yes. Any employee who is eligible for PFL can use PFL either continuously in week increments of 1 full week or intermittently in increments of 1 full day. Okay, next question here is, are PFL benefits paid to employees on leave taxable? And the answer is yes. So the board does not have jurisdiction over tax matters, but the New York State Department of Taxation and Finance did issue a notice about kind of tax implications for PFL, and that's notice N-17-12. And that notice says that benefits paid to employees is taxable non-wage income that has to be included in federal gross income. Okay, next question here is, if my kids get sick with COVID, how many times can I ask for PFL? So this is kind of like a multi-part. Firstly, if we're just talking about COVID-19, the quarantine leave benefits are only available when an employee or their minor dependent child is actually under an order of quarantine or isolations, a mandatory precautionary order of quarantine or isolation. It is not just I have COVID or my kid has COVID or has had COVID for a few weeks and they still don't feel well. It's only specifically when you are under an actual order of quarantine or isolation. If we're talking about a child who is sick, like they have a serious health condition related to COVID, then you may be able to get PFL to care for a family member with a serious health condition, which includes child. And that's the maximum of 12 weeks. The COVID leave, it really depends on the size and type of your employer, whether or not you're eligible for COVID-19 quarantine PFL. So if you go to the paidfamilyleave.ny.gov homepage and then click the COVID-19 button, it's like in a banner just right on the home page. If you click that, that'll give you kind of the rundown of the benefits that are available to you, but paid family leave for a quarantine is only if you are actually under an order of quarantine or isolation. If we're talking about a serious health condition, that's the maximum of 12 weeks, and that's separate from the quarantine leave. So it would just be the serious health condition. Okay, next question here is, if I am employed by multiple employers and each employer is taking PFL deductions, can I complete the PFL exemption form for the employer that is not my main employer and still take PFL if needed? So eligibility, benefit amounts, and deduction amounts are all calculated separately per covered employer. So if you work like a full-time job with employer A, for example, and you become eligible for PFL with that employer, you remain eligible with that employer for PFL until your employment is terminated. If you work for a second employer and you qualify for a waiver and you fill out the waiver, that waiver just means that that employer, you can't take leave from that employer, and that employer won't take any deductions from you. It doesn't have any bearing on your eligibility for PFL from employer A. The only thing to keep in mind when you have multiple jobs, though, is that, obviously, if you filled out a waiver, you can't take leave from that employer, but if you are eligible for PFL at multiple employers and you have a qualifying event, You don't have to take it from all of your employers, but if you take PFL, you have to take PFL from all the employers for that qualifying event at the same time, like all the employers that you plan on taking PFL from at the same time. So you couldn't do, like, if you're eligible at job A and job B and you want to take bonding leave, you can take bonding leave from both or just one of those employers, but you couldn't say, I'm going to take bonding leave now from employer A, and then 6 months down the road, I'm going to take bonding leave at employer B. So you can't do that. You would have to take all the leave from all the employers for that qualifying event at the same time. But you don't have to take it. And if you've executed a waiver, obviously you're not going to be taking it from that employer anyway. Okay, next question here is, can I provide any guidance on the COVID-19 requirements and what may be changing in the next few months? So again, if you go to the paidfamilyleave.ny.gov page, and then there's a banner right on the front when you go there, you can click the COVID-19 page, and that gives you kind of the overview of the benefits. There is also a proposal that has not been passed. It's just a proposal that would have an expiration date for the COVID-19 quarantine leave, but again, that has not been passed yet. It may be passed, may not, but there is a proposal out there, so it's possible that there could be an expiration. But again, it is still just a proposal at this time. It has not passed the legislature. Okay, next question here is, can employees utilize PTO to supplement the PFL? So employers can't force employees to use accruals during a period of PFL, but they can allow them to if they want. So employees can top up, so using some PTO to top up that 67% so that they receive full wages during a period of PFL. An employer who pays full wages during a period of PFL can also request reimbursement from the carrier. And that's in accordance with Section 237 of the Workers' Comp Law. But yeah, so as long as the employer isn't forcing the use of accruals during a period of PFL, they can offer the employee the choice, and that is acceptable if the employee chooses. Okay, next question here is, did I say that FMLA is hourly and PFL is daily? Yes, so FMLA, the federal unpaid leave, can be taken in hourly increments. PFL cannot. Right now, it is only available in continuous increments of like weekly, so continuous, or increments of 1 full day. PFL is not available hourly under the law. Okay, next question here is, there is a weekly cap, but is there a daily cap if they only use 2 days a week? Would they just get 67% of their daily rate? So yes, there is a daily rate as well, and that's in section 380-2.5 of the regulations, and that gives you kind of a overview of how that's done. So essentially, it's going to depend on how many days a week that the employee works, and depending on the number of days of a week, their weekly benefit is going to be divided into that amount. So when they take it in daily increments, it's going to be their average weekly wage divided by the average number of days the employee worked per week. So that's how you get to the intermittent daily rate. Okay, I see a question here about taking PFL intermittently, but the employee doesn't always know when they're going to need PFL because they have a spouse who has epileptic seizures. How does that work with benefits? Are their benefits still maintained? So there are notice requirements with PFL, including intermittent PFL, but the notice for unforeseeable leave is just as much notice as possible. So obviously, if these are emergency situations and the employee doesn't know, they need to let the employer know as soon as they can, but it's as much notice as possible. So it may not always be possible to give to give 30 days notice or something like that, but they have to give as much notice as possible. And this doesn't affect their eligibility for PFL, so it could be that the healthcare provider has certified, X number of days per month or something like that, that the employee's family member may need care. And then if an epileptic seizure or something like that happened on a day that they're not scheduled to work, like they find out that they need to stay home the next day to care for their spouse or something, a day of PFL is defined in the regulations as any full day that the employee was prevented from performing work for the covered employer because the employee used PFL. So if they don't have a lot of notice, but it's not a day, like the next day is a day that they wouldn't normally work, like a weekend, or a day that they're not scheduled, they may not be eligible for PFL for that day. Okay, next question here is if someone is applying for child bonding, what is the appropriate timeline for them to begin to file? So employees have 30 days from the first day of leave before they risk losing benefits. Like I was talking about earlier, some carriers allow pre-filed claims, especially for bonding, but they are not required to allow pre-filed claims. And the employee is not eligible for bonding leave until after the child is born or placed for adoption or foster care. Okay, next question here is when adding up hours for part-time employees, does the total have to be a total of 175 per year? So eligibility doesn't use hours except in the case of like determining whether or not they're on the 26-week timeline or the 175 days worked timeline. So if an employee regularly works 20 or more hours per week, then they're going to be eligible for PFL after 26 consecutive weeks of employment, versus if they work less than 20 hours per week regularly, they're going to be eligible for PFL after working 175 days. And then when we're talking about 175 days per year, we're talking about whether or not like a part-time employee qualifies for a waiver. So an employee who regularly works less than 20 hours per week and won't work 175 days in a year, that employee qualifies for a waiver, and the employer has to provide them the option to opt out of paid family leave deductions. Okay, next question here is if a person goes out on PFL when his wife goes to have a baby, can he work in another job? So generally speaking, there's no prohibition on someone continuing to work a job. However, they cannot work for the covered employer at all during paid family leave, and B, for any other employer during the same or substantially similar hours as the employer from which they're taking paid family leave. Because paid family leave is a wage replacement benefit, and it's to use when the employee is prevented from performing work because they're on paid family leave. So generally speaking, like they can continue working another job, but it can't be during the same or substantially similar hours as their job that they're taking PFL from. Okay, I see a couple questions here about holidays and paid family leave and the interaction of those. The interaction of holidays and paid family leave is not explicitly addressed in the PFL law or regulations. Generally speaking, if we're talking about like a day of paid family leave, again, is defined in the regulations as any full day that the employee was prevented from performing work for the covered employer because the employee used paid family leave. Okay, next question here is one employee filed paid family leave and then decided to quit the job before the paid family leave day starts. Is the employee still eligible for taking paid family leave after he quits the job? So generally speaking, I can't provide legal advice, which includes eligibility determinations for particular individuals, but generally speaking, PFL is a benefit for employees in employment with a covered employer. If they're not in employment, they're not eligible for paid family leave, but if, for example, an employee decides I'm not coming back to work after paid family leave and they give notice of resignation that takes effect after the period of paid family leave, they may still be eligible for PFL benefits. But if, for example, they gave resignation with an immediate effective date, like before they start PFL, then they may not be eligible. So it's very, very fact specific, and it's going to depend on whether or not they are in employment or not. Okay, next question here is if you have PFL deductions from multiple employers and then you apply for PFL at all of those employers simultaneously, do you receive the PFL benefit from each of the employers? Yes. So if you have multiple employers and you're eligible at multiple employers and say you're taking bonding leave or something like that, and you have to apply at each of the employers. So everything is calculated separate. So benefit amount, deduction amount, and eligibility is all calculated separately for covered employers. So if you're going to take PFL from all of your employers, that's fine. It's just going to be however many, say you have 3 employers, you have to apply at all 3 of them, but your benefit amount is going to be calculated separately per covered employer, and you're going to get paid by that employer's insurance carrier for all 3 different applications.
Thank you, Courtney. It is 1 o'clock. I do see we have a few questions that we did not get to answer. We apologize for that. However, again, you can see the paid family leave homepage on your screen as well as the helpline. If you really need an answer to your question, feel free to reach out to there. Or before we sign off here, please resend your question with your name and email address, and we can follow up with you that way. Before we do sign off, again, I want to give you one more quick plug for public employers or HR representatives of public employers. We are going to host a webinar specifically for you next Tuesday, March 5th. Go to the Paid Family Leave website, go to the webinar page. You can sign up there. For any other employers, if you have any additional questions on paid family leave or any workers' compensation or disability benefits questions, feel free to join our webinar next Wednesday. If you can go to the Workers' Compensation Board website, that's wcb.ny.gov. There's a webinar page there. You can sign up for that one. We want to remind you before you sign off that you can receive paid family leave news, including information on future webinars, straight to your inbox. To sign up, just go to the Paid Family Leave website, scroll down to the bottom of the home page and select Get Updates. We do also distribute information via social media, so make sure you're following the Workers' Compensation Board on Facebook, X, Instagram, and YouTube, where you can find previously recorded versions of this webinar and more. And again, before you sign off today, we are going to direct you to take a quick survey. We want to know how you think we're doing with these webinars, any suggestions you have for us to help us improve them. We always appreciate your feedback. And again, we want to thank you for joining us today. Thank you as always to Courtney for taking the time to answer your questions. And we hope you have a good day, and we will see you for our next session, hopefully. Thank you.